Welcome, everyone, to Election Year Considerations for Nonprofits, What Your Organization Needs to Know. Thank you very much for joining us today as we kick off the election year 2022. We have a great panel lined up for you today with Jim Terrell and Lindsay Nathan, two of our partners in the political law practice at the firm. Lindsay has a wide background in state government experience, as well as working for some of the larger nonprofits that are politically active in the country. Jim represents a wide variety of clients in the political law space and has clerked for a federal election commissioner, so has great practical experience. Lindsay and Jim are going to take us through the whole panoply of political law today for nonprofits, and particularly in an election year. We can go to the next slide, please. We will cover a whole variety of different issues of 501c3 activity, as well as 501c4 and 501c6 activity. So regardless of what kind of organization you represent here today, we have a lot of great content to go over with you. There is continuing legal education credit being offered. There will be a code that gets read in the middle of the presentation, so pay attention for the secret message so that you can claim your CLE credit. The next slide, please. So I want us to just start off very briefly before we turn it over to Lindsay and Jim to talk a little bit about sort of why it matters and why it's important that you're all here today to learn about political law for nonprofits. The next slide, please. So, many of your organizations are politically active, or you may want to become more politically active in state and federal politics, legislative activities, the whole range of different things to do. And there are really a lot of risks and rewards that come with it. Obviously, many organizations need to be involved for their members, for their constituents, to try and be involved in the political process. And so it's important to know how to manage those risks that come along with that. And that's what we hope to help explain today is sort of both the risks and the rewards and how to balance those kind of concerns. So obviously, to be politically active, it can help to protect your organization, their members, their interests, find new opportunities, really enhance your reputation for being involved in the political process, and help to establish, particularly in the trade association space, a favorable regulatory climate for your members and their businesses. So there are a lot of risks, though, and that's what we hope to kind of talk about today and make sure you know how to deal with them. The laws vary widely. We're going to focus primarily on the federal laws and how they work, but know that there are also a lot of state laws that we'll touch on as well. They can really present problems for both personal political activity as well as organizational political activity. And it's really important to think about this as a whole holistic compliance effort that involves the entire organization, so you can avoid those fines and reputational risk. And my view is really that the reputational risk is one of the biggest impediments to successful political activity. There is scrutiny from regulators, the media, competitors, different watchdog organizations that are out there, and they're going to nitpick and scrutinize what's going on. And so that's why it's important to have a great compliance program in place so that you can successfully engage in the political process. So now I will go on to the overview of the legal issues, and I will turn it over to Lindsay and Jim to take us forward.
Thanks, Ron. So now I'm going to spend just a brief moment talking about the general legal framework that we're working in. So as many of you know, when we talk about nonprofit organizations, for the purposes of this presentation, we're going to talk a little bit about 501c3 public charities, as well as 501c6 trade associations and 501c4 social welfare organizations. As you can see on this slide, this is sort of the brief overview of kind of what you can and can't do for each of these types of organizations. So the key takeaway for a 501c3 public charity is that you cannot engage in any campaign intervention, which we'll talk about in a little bit. Generally speaking, we're talking about endorsements, contributions to candidates, or any kind of communications or activities that are support or oppose candidates for office. While you may engage in some lobbying, it may not be a substantial part of your organization's activities. And on the other hand, you can engage in unlimited issue advocacy as long as it doesn't meet that tax code definition of lobbying. On the flip side, for C6 and C4 organizations, you can engage in some campaign intervention, although it has to be limited so that it's not the organization's primary purpose. You can contribute to candidates in some circumstances, although not federal candidates. You may have some interest in forming a connected political action committee or a super PAC to make independent expenditures, and there are lots of reasons for wanting to do those things. And you may make communications directly to support or oppose candidates, although we'll talk about some disclosure issues that have popped up in the recent years. In addition, you can engage in unlimited lobbying and unlimited issue advocacy. So when we're talking about lobbying for a 501c3 organization, we're really talking about attempts to influence legislation. The definition of lobbying for a C4 or C6 is slightly broader than that, but since those organizations can engage in unlimited lobbying, it's really important that C3 organizations understand that it's about attempts to influence legislation. When we're talking about campaign intervention, just briefly, we mean supporting and opposing candidates, although there's, of course, more nuance to all of these things. For a basic overview of campaign contribution rules, corporations and nonprofits may not give to federal candidates. State laws may vary, although for 501c3s, we already mentioned that you can't give to candidates. Foreign nationals are prohibited from making political contributions and may not control the political activities of an organization. Contractors are subject to limitations, and there are pretty strong rules about making reimbursements to employees or organizations, and you need to understand what the restrictions are with respect to earmarking political contributions through other organizations. Just as a general rule, when we're talking about contributions, we mean payments, direct cash contributions. We also mean in-kind contributions. So anything of value that a candidate or a political entity would otherwise have to pay for will be treated as an in-kind contribution and subject to the same contribution limits and prohibitions as a cash contribution. That's true as well for a coordinated expenditure, and we'll get into the definition of coordination a little bit later. When we talk about expenditures, we generally mean independent expenditures. So if you're spending money to support or oppose a candidate and that expenditure is independent of that candidate, that's what we mean when we talk about expenditures. Those are typically unlimited, although there are some donor disclosure and other issues that we'll talk about a little bit later. And one brief comment about tax on political activity. Under 527F of the Internal Revenue Code, there is a tax that is assessed on the lesser of net investment income or political expenditures for 501 organizations that engage in political activity. The tax is 35% of the either investment income or political expenditures amount. And for purposes of the tax code, if you have a separate segregated fund and it pays its own tax, it's treated as a separate entity. So now we'll get into the conversation about 501c3 organizations. As I mentioned before, a 501c3 cannot engage in any political campaign intervention, but there's still a lot that can be done with respect to participation in elections. So just as a framework, our 501c3 wants to be involved in the upcoming elections, but we don't want to jeopardize our tax-exempt status. What can we do? Are we allowed to talk to candidates and voters? Can we make contributions? I'll say it again, I'll say it 100 times during this presentation. 501c3s cannot engage in any campaign intervention. It means you can't make any contributions to candidates. You can't use any corporate resources or organizational resources to support or oppose candidates. And you can't put together any events or activities that are designed to benefit a candidate, regardless of whether or not you mention the candidate's name. And finally, you can't make any endorsements. On the other side, you can actually engage with candidates, and you can do a lot of other activities that to participate in elections, as long as they're done in a way that is non-biased and nonpartisan. So some of those things are, we'll talk a little bit about interactions with office holders who are candidates. So current elected officials, you're certainly allowed to continue engaging with elected officials. You can potentially host a debate or a forum with some limitations. There are ways to continue to communicate on issues that don't actually, that won't amount to campaign intervention. You can continue to do scorecards, legislative scorecards, and send questionnaires to get people on the record on particular issues. And some organizations can do nonpartisan get out the vote and voter registration drives, although there are some restrictions there as well. In terms of interacting with candidates, there are some key things to keep in mind. You can certainly lobby candidates as well as elected officials and get them to support the issues that are important to your organization. On the other side, you can't ask a candidate to take a pledge or to run on a particular platform. You can put together materials that you can share with all of the candidates or share with candidates upon request. That includes policy papers, overviews of your issues, any kind of lobbying materials, really. But you shouldn't do that at the request of a candidate. You don't want to make an in-kind contribution to that candidate. Remember, that means that you would be making a contribution of something, services or some other item that is of value that they would otherwise have to pay for. In terms of debates, if you're thinking about hosting a debate, there's some key takeaways. Just make sure that all candidates are invited. You don't have to invite everybody. If you have a large candidate pool, you can use some objective criteria to create a reasonable size for your debate. You can do it with only one party if you're hosting a debate during a primary election. But again, it has to be, you have to invite all the candidates unless you have some sort of threshold for invitation. You need to make sure that the questions and the topics that you're discussing during the debate are neutral, and you're not allowed to make any endorsements. Similarly, with candidate forums, similar rules apply. You should invite all candidates, although again, reasonable restrictions can be imposed. You want to make sure that you're giving equal time to each candidate so that you're not favoring any candidate over another. You want to make sure that the questions are neutral and that there are a variety of questions as well. To the extent that you do candidate questionnaires, there are a number of factors that you want to sort of keep in mind. You want to make sure that you are, as you can see from this slide, the things to kind of keep in mind for all of these items are to make sure that all of the candidates are getting the questionnaires, that the questions are drafted in such a way to get clear and unbiased responses. You want to make sure that there's no indication that you're going to endorse as a result of answering the questions. You're not asking for pledges of support. You want to make sure that you're giving reasonable time to respond and that you're giving candidates an opportunity to support, to explain their position if you're asking them to support or oppose positions. For legislative scorecards, it's similar to all of the other things, but one thing to keep in mind here is that you want to make sure that the legislative scorecards are not issued to coincide with election timing. So, they should be related to recent legislative sessions. So if it's something that you routinely do where you score legislators on their on how they voted on particular issues, for example, you want to make sure that it's tied to the legislative session and not the election cycle. You want to track a variety of issues. You want to include all of the legislators, but you shouldn't include anybody who's a candidate and not a sitting incumbent. And finally, on voter registration and get out the vote activities, these can be done, but they have to be done in a nonpartisan and non-biased way. So you can't target voters of a particular party or demographic in such a way that it would favor one candidate over another or a group of candidates. Issue ads. So what about issue ads? Our 501c3 already does some grassroots lobbying. Do we need to stop now that the election is coming up? So it's a good question. So one thing we wanted to mention was that there isn't a clear answer to this question, but you want to sort of take into account all of the various factors that the IRS will consider as it's determining whether something is campaign intervention. So if you're running an ad and it IDs one or more candidates, it's close in time to the election, and it approves or disapproves of that candidate's, that elected official / candidate's position on that, it may be perceived as electoral campaign intervention, even if it wasn't intended to be. On the other hand, if you have ongoing communications related to a particular bill. So say you have an ad campaign and it's going on, and you've run several ads to lobby the public to call their legislator on a particular bill. It might not be seen as campaign intervention. So the key thing to remember here is that context really does matter for these things. That if it looks like it's going to be campaign intervention, it probably is. But if it's something that you've routinely done, then you might have a little more latitude. All of these things are really fact specific though. So to the extent that you're thinking about running advertisements where you're going to be including candidates, you just want to make sure that you're talking to your counsel and that you really understand what the rules are, because obviously the downsides are pretty significant. So an example of that. So if you have two similar ads, on the one hand, you're calling Senator Smith to thank her for a vote on Senate Bill 123. So if you look at the timing, it's 1 week before the election. Senate Bill 123 is a really contentious issue in the race. It's not lobbying because you're not actually asking the senator to support that bill. You're not asking people to call Senator Smith to vote for or against that particular bill. It really, you're looking at it and you think, well, this is really about supporting that particular candidate. So that could be campaign intervention. On the flip side, if you're calling Senator Smith and asking her to vote no on Senate Bill 123, it's a little bit closer in time to the legislative vote. It's definitely grassroots lobbying, either under the legislative definition or under a more expansive definition of lobbying. It might not be campaign intervention, depending on the timing. Again, I would encourage you to chat with your counsel and make sure you're clear about the rules before you run either of those ads if they're close in time to the election. Websites and social media. So we get a lot of questions about websites for affiliated organizations. So to the extent that you have, you're a 501c3 and you have an affiliated or related 501c4 or C6 organization, how do you have a website that connects and social media that connects those two organizations without jeopardizing the tax exempt status of your 501c3? So there isn't a 100% clear answer on this, but it's important to keep in mind that you should treat these as any other communication and look at it the same way that you would look at issue ads or anything else that you're doing on an organizational level. So if you have, for example, a PDF, which is a legislative scorecard, and that's something that you routinely do from your C3 every legislative session. And next to it, you have a blog post that's criticizing the vote of a particular legislator that's included on that scorecard. It's probably going to be seen as campaign intervention, even if you weren't necessarily intending it to be that way. So you just want to be very careful that you're not including information on your website that's going to potentially impact your C3, or you don't want to include C4 or C6 appropriate information on your C3 website in such a way that it would potentially impact the C3. So for blogs and third-party postings, it's a little bit unclear as well. It's important to have disclaimers to make sure that people understand that the views expressed on the blogs, especially if the comments are open to the public, are not necessarily expressing the views of the organization. In that situation, the comments may be okay. You can't really control what people are going to say on your site, but you just want to be very careful about that. In terms of having links on your websites, linking to candidate sites is a little bit tricky. You want to make sure that if you're doing that, the context is very clear and it's very clearly aligned with your voter education, your nonpartisan and non-biased voter education activities, and that you're including all candidates on that. If it seems like it's advocating for or against a particular candidate, if you're an issue-based organization, for example, and you're including candidates' positions on those particular issues and pointing to their campaign websites, likely that will be seen as campaign intervention. So you just want to be very careful that you're not doing that in a way that will cross that line. If you link to other sites, you want to think through the purpose of making those links. You want to tie it back to your advocacy efforts, your lobbying or issue advocacy efforts, and make sure that it's not campaign intervention. And to the extent that you can, you want to increase the number of clicks between the the organization. So if you're going from your C3 to your C4 site, for example, having multiple clicks to get there, or having some, something where it's the C4 content isn't directly on the C3 site is really important. Executive endorsements. So a lot of organizations ask this question, which is, their C3 CEO would like to engage in elections. They want to endorse a candidate. They want to make personal contributions. And how does that work with the organization? And what can the organization do or not do? So the key thing to keep in mind is that an executive can endorse in his or her personal capacity. You don't lose your First Amendment right to engage in politics just because you happen to work for a public charity. However, you cannot use any of the C3's organizational resources to make those endorsements or to engage in any of that political activity. You can use your title for identification purposes only, but if you do use your title, you need to make sure that it's clear that the organization was not involved in any of the election activities or endorsement. So here are a couple of examples. If you have, you see Sally Smith is the executive director of Neighborhood 501c3, the views presented here are hers and not those of the organization. We have a couple of other examples on this slide. But the key is that it's very clear that the organization is not making the endorsement, but the individual is. If your executive wants to fundraise for candidates, that's also fine. But again, the C3's resources may not be used. That includes the facilities and the space, the mailing list or the email list, and the CEO has to use his or her personal contacts. The other thing is, I said CEO, but this would be true for any employees of an organization. For home fundraisers, just as a reminder, the FEC allows $1,000 per person per candidate for food and beverage, and anything over than that would be considered an in-kind contribution. Again, that's not organizational resources, but if the executive or individual wants to host an event in their home, then they can avail themselves of that $1,000 without becoming an in-kind contribution. For state candidates, it varies quite a bit. In any case, the candidate can always pay for any expenses related to a fundraiser without having to worry about in-kind contributions. And now I'll turn it over to Jim.
Thank you, Lindsay. So the next, so Lindsay went over 501c3 organizations, and I'll touch on 501c4 and C6 organizations, which can do significantly more, work in the campaign space because they're allowed to do so. So a 501c4 and a C6 would like to endorse and support candidates in the upcoming elections. How can we get involved? So first off, what is campaign intervention? Lindsay touched on it. The IRS has a sort of amorphous test, a number of factors that is really different, called the facts and circumstances test. And Lindsay went over that. A lot of it has to do with the timing, content, and background of the communications that you may be doing. And intervention includes express advocacy. Those are vote for, vote against language in independent expenditures, campaign contributions in states where corporate contributions are allowed. That would qualify as campaign intervention. Contributions to political committees. So a lot of groups will not do direct expenditures from the organization, but they'll make contributions to super PACs, which then make independent expenditures. That would qualify. Endorsements would qualify, as Lindsay alluded to, as well as supporting a connected PAC that the organization has. So supporting and opposing candidates. Under federal law, as Lindsay had said, contributions, corporate contributions are not allowed. But after Citizens United in 2010, expenditures and independent expenditures are allowed in unlimited amounts. State law is a little different. It kind of varies. Some states do allow corporate contributions, so they can take direct contributions from some of your organizations if they're organized as a C4 or C6. And again, going back to the tax law, C4s and C6s, no matter how much they engage in political intervention, it can't be their primary purpose. So primary purpose, the C4. So how is that exactly calculated? Social welfare organizations, which is how they're deemed under the code, engage in a number of different activities that could be considered social welfare, which include education, coalitions, grassroots lobbying, other types of lobbying, any kind of things that are kind of in line with the main objective of the organization. As far as political intervention goes, that usually takes the form of independent expenditures, whether that's directly or giving it to a super PAC, or making direct contributions in states where it's allowed. Fine. And then as far as a C6 goes, similar criteria for C6s. C6s are representing certain industries, and so they do a lot of education and training in those spaces for their individual industries, lobbying for regulatory changes, summarizing regulatory changes for their members, and engaging in lobbying. And as far as political campaign intervention, again, usually takes the form of independent expenditures or contributions. And I'll say, many lawyers will kind of differ on this, but as far as a percentage safe harbor, when you're talking about calculating these things, it needs to be under 50% in political expenditures, but generally speaking, a good safe harbor would be 60% in social welfare spending and 40% of political spending. And again, that's kind of a gray area. There hasn't been any kind of set in stone rules by the IRS, but most folks will say the safe harbor 60-40 is rational. So independent expenditures, and this is what Lindsay was talking about earlier. After 2010, these obviously in the Citizens United decision, many organizations were brought into the fold in their ability to participate and do ads and make communications that oppose or support candidates. And so, say an organization wants to run ads and oppose candidates. Can we do that? Should we set up a super PAC? So making independent expenditures on sort of the base level, what's the purpose? It's to support candidates through various types of communications or oppose candidates. And that independent expenditures will typically have a vote for, vote against language in it, but not always. The key, though, with independent expenditures, and you'll hear this a lot in the media about, oh, well, there can't be any coordination. And that's very true, but it's oftentimes misunderstood. And the FEC has specific criteria as to how that's determined. So under the Federal Election Commission regulations, there are 3 prongs to the coordination test. First is payment, which is not listed here, but it's always assumed if an outside group sponsors an ad. Content, what is in the ad? Does it contain language in there that would qualify it to be a coordinated ad? And then conduct, and conduct is really kind of where you get into the meat of the determination. What kind of activities or interactions were outside groups or your organizations having with candidates such that a communication sponsored by that outside group could be considered coordinated? So we'll deal with content first, and content. There's a number of different types of ads that could qualify under the coordination test. One is electioneering communications. So that's basically any kind of broadcast, cable, or satellite advertisement run to the relevant electorate 30 days before a primary election or 60 days before a general. The second type of ad is really just express advocacy communications, which the FEC has a test. It's really express advocacy is 2 things. It's either vote for or vote against, that sort of language, or what the FEC likes to call functional equivalent of express advocacy, which is kind of a highly litigated thing as to what it amounts to, but that's what counts under the content prong. And then reference to candidates in public communications, and then republication of campaign material, which is really just taking a candidate's committee's ads or billboards, whatever it may be, and just republishing it. That would qualify under the coordination test. So what is not a public communication? So anything on the internet that is not paid for on a third-party site. So email, blog, social media, you post something on Twitter, that does not count. However, if you place paid ads on Twitter, that does count. So the key is whether you're paying a third-party website to air that ad. Also included are things like banner ads, so digital banner ads, targeted advertising, and paid social media. And then one thing we'll note is that any expenditure for republication of candidate materials is an in-kind contribution from the organization. So conduct problem, and I'm not going to get too deep in the weeds here, but generally speaking, as I said, conduct deals with how individuals from an outside group might interact with the candidate committee such that it would deem a later expenditure to be coordinated. And so the gist of this is that private material, non-public information not be relayed from a candidate's campaign committee or an agent of that campaign to an outside group, where the outside group then does the independent expenditure or does the ad. And so I'm not going to get too into the pieces here, but one other thing is that a common vendor, sometimes organizations can get tripped up because the candidate who they want to target an ad has the same media consultant or pollster as the outside group or one of your organizations. That could be fixed. That can be, the FEC has said that that's not a problem as long as there's a firewall policy in place. But these are the types of things that the FEC would look to in a coordination analysis. So as far as disclosure of independent expenditures, the FEC is once you register a super PAC or you have an outside group that's engaging in these types of activities, there's resulting disclosure regimes. And for super PACs, there's periodic reports, quarterly reports, there are semi-annual reports in the off election year. So this year there'll be the regular quarterly reports, as well as 48-hour reports, which are any kind of express advocacy communications that take place 20 days before or more before an election. And then there's 24-hour reports where if an organization sponsors an ad, they need to disclose that ad in a report filed with the Federal Election Commission within 24 hours of the ad going live. I think, Lindsay, you were going to touch on this donor disclosure piece.
Yeah, I just wanted to make one note about donor disclosure. So for many years, C4s were pretty active in making independent expenditures and spent lots of money to support and oppose candidates without having to necessarily disclose donors. So prior to this court case, which was decided by a federal district court in 2018 and then affirmed by the DC Circuit in 2020, the FEC had a regulation that required disclosure of donors only who funded particular federal independent expenditures. So if you were raising money for your federal election program but didn't earmark any of those contributions specifically for a particular independent expenditure, then you wouldn't necessarily have to disclose any donors who gave to the organization when you were filing your independent expenditure reports, which was a pretty big loophole in the donor disclosure rules because organizations, super PACs, for example, that were registered with the Federal Election Commission would have to disclose all contributions over the itemization threshold. Since this decision came down in 2018, all C4s now have to disclose donors who gave $200 or more during the reporting period for the purpose of supporting the organization's attempts to influence federal elections. What that means exactly is a little bit unclear. The FEC hasn't issued any regulations to further refine this. And so most organizations are taking a slightly more conservative approach to how they're running their independent expenditures now to avoid inadvertently disclosing donors who gave not, maybe for the purpose of supporting the election activities, but didn't give for supporting particular independent expenditures. So one thing we wanted to mention to you all is that it's really important to be careful with your fundraising solicitations, because if you're fundraising for particular elections activity, it could potentially expose your donors. If that's something you're concerned about, then it's something to keep in mind. The other thing to think about is whether, if you want to run independent expenditures, whether it makes sense to set up a separate super PAC or organization, specifically for that purpose.
Great, thanks, Lindsay. So, and just getting back to some of the pieces on independent expenditures with respect to the states, Citizens United, although it dealt with federal races and candidates and issues, the same law applies to all the states, and so every state, not every state adopted laws that comply with Citizens United right away, but now ultimately all states allow the same level of independent expenditures. Corporations, associations, many types of groups who are on this call can actively engage in independent expenditures on the state level. Now, as far as the rules with respect to coordination, those rules do differ, and so that's kind of a case-by-case analysis. Some states are more strict than the Federal Election Commission. Some are not at all. Some allow corporate contributions, in which case the coordination regulations don't really matter because you can make corporate in-kinds in unlimited amounts. So contributions in general. How can we make contributions to state and federal candidates and political parties as an organization? Should we form a PAC? So first off, I think it's important to go over some of the federal contribution limits. I'm sure many folks on this call are familiar with these. Individuals can give $2,900 per election to candidates. Party committees have different levels of limits. And as far as PACs go, a multi-candidate PAC, which we can explain later, can give $5,000 per election to candidates, which would mean that $5,000 for the primary and $5,000 for the general. And as we said earlier, corporations and nonprofits on a federal level are unable to give to candidates. And here's a chart we just put together of all the states and how they deal with these issues. Many states have prohibit corporate contributions, others do not, and others allow. And some states have kind of a hybrid regime where corporate contributions are allowed to certain types of entities, but not to others or not to candidates. So things to consider when we're talking about.
Sorry, Jim. I wanted to make sure we remind the audience of their CLE code. I think we're.
Oh, that's right. Yes.
Halfway through.
CLE code was election 2022.
So election 2022 is your CLE code for today. Go ahead, Jim.
Thanks for reminding me of that, Ron. So things to consider with respect to contributions in general. Are there restrictions on contributing during the legislative session? Many states have these sort of restrictions. Are there limits on lobbyists and fundraising and making contributions? Those are often an issue in states. Some states require board authorizations for various contributions. And as Lindsay discussed earlier, there's also the 527F tax to keep in mind. And some states require donor disclosure, and that kind of varies across states. So one of the major ways that organizations, 501c6, 501c4, and just for-profit corporations are able to make contributions to candidates both on the federal and state levels or through political action committees. Political action committees, and when I say political action committees, I mean really separate segregated funds, corporate PACs, that are associated with or tied to, connected with a various one corporation or an association. So political action committees, they're used to make contributions to candidates, $5,000 per election to candidates on the federal level. No corporate funds in the account, so the corporation is not transferring funds into a separate segregated fund account, and it can receive up to $5,000 per calendar year, and only U.S. citizens and permanent resident aliens are allowed to make contributions to the PAC. So connected versus a non-connected PAC, and again, connected PAC has really a sponsoring corporation or association. A non-connected, though, is not related to a corporation and can solicit any U.S. citizen, but all administrative costs need to be paid out of the net earnings of the PAC itself. On the other hand, a connected PAC, connected to say separate segregated fund, is related to a corporation. It can pay for the administrative costs. That includes fundraising, accounting, reporting costs, compliance costs. But the key here is that the PAC can only solicit the restricted class of that organization. So what is a restricted class? Restricted class kind of varies by the different type of organization. Restricted class are the individuals who may be solicited to make a contribution to the PAC. And it varies according to the organization. There's a regular for-profit corporation, membership organizations, trade associations, etc. So for a corporation restricted class, so say just a for-profit corporation has a PAC, separate segregated fund, it can solicit salaried employees with policymaking or managerial responsibilities, members of recognized professions, stockholders, board of directors, and family members of all of those folks. An individual membership organization, which may not be not a trade association, is the PAC can solicit salaried employees of the organization with policymaking responsibilities. Again, members of a recognized profession, the members of that organization, as well as family members of all of those people. And then a corporate membership organization, like a trade association, is the trade association or the corporate membership organization's PAC can solicit, again, sort of the same type of people, but there's also, you can solicit non-corporate members if there's individual members, salaried employees of the member companies. But the key here is that there needs to be what's called prior approval, which is often the bane of existence to many trade association fundraisers and corporations who want to be members of numerous trade associations. So trade association solicitation. The association may only solicit executives of member companies, but only if the member company gives prior approval. And prior approval, the rules are somewhat strict in that only one association per company per year. So if I'm a company and I'm a member of, my company's a member of 5 different trade associations, the company is only allowed to give authorization to one of those association PACs to solicit their restricted class. The prior approval needs to be in writing. The company can limit the scope of that solicitation, and it also may include a sample solicitation in there. So fundraising for the PAC. What are some things your organization can do to have your PAC gain popularity and raise significant funds? And a number of activities that PACs have done over the years. Obviously, there's reception and dinners with some senior leadership. There's giving out little prizes or trinkets. There's something called PAC Match, which entices folks to contribute to the PAC, and the corporation will match that amount to that person's favorite charity. So one piece of this, though, is that if it often happens with the corporate PAC or trade association PACs for various fundraisers, is that the value of a prize that is given for any of these various promotions needs to be less than 1/3 the value of the contribution, and the PAC must pay any excess that's received. So it's important to keep in mind, the universe of contributions. If you're an association, you're having a bunch of your members donate items for an auction or some other type of event, it's important to keep track of the fair market value of those things, to keep track of the 1/3 rule. Just an example of the 1/3 rule: if there's a raffle and there's $1,200 in contributions, the prize can be worth no more than $400. And as far as gifts go, an example would be like a $10 pen. The contribution must be more than $30. And just building on that, as far as prizes and awards, subject to the 1/3 rule, it can be paid for by the connected organization. So in that case, it can be paid for by the connected organization, but it's always keep in mind the 1/3 rule. And then if a trade association is having the promotion, the member companies using corporate funds may donate the prizes. So PAC Match, Charitable Match, which is the FEC had approved years ago, would allow, again, it entices folks to contribute to the PAC, thinking that they're going to be able to have a contribution to their favorite charity as well. A couple of rules with that, though. There can't be any benefit to the contributor, so no tax deduction, anything like that. No token gifts, and no deduction for the organization either. That's an important thing to keep in mind. As far as the charity, it can be limited by the company to a specific list. The company can provide a number of options, including a related foundation. So oftentimes there's a related C3 to these types of organizations that can be part of a PAC Match program. It can be open to any C3 though. And there should often be a system that kind of verifies the charities before they're provided as options. And as far as the, how much can they match? The FEC has said that a 1-for-1, match is permissible, but they did not come to a determination on a 2-for-1 that was dismissed in an enforcement action. So as of now, it's really the 1-to-1 PAC match that most organizations do. And then, as many of you know, go ahead.
Sorry, Jim, before we get to the FEC reporting piece, we had a question that came in on the Q&A, and I'll use this as just a reminder first that we do have the Q&A chat available. Feel free to ask any of your questions through there that you might have. But one of our viewers asked about if they wanted to form a PAC, what kind of corporation or LLC or business entity would the PAC be? The question goes on and asks about 501c6, C4, or other. And I thought it was a very interesting question because I know I often get similar questions about sort of what is a PAC in the corporate law. And I think part of this may depend if they're talking about a non-connected PAC, it's sort of its own thing, or a connected PAC as part of an existing organization. So either Jim or Lindsay, if you wanted to answer that for our viewer.
Yeah, I think it's important to know that whenever you're setting up a PAC, a PAC is not a C6, a PAC is not a C4. A PAC is organized under Section 527 of the Internal Revenue Code always. So if you talk about a presidential campaign or a separate segregated fund, it's organized under Section 527. Now, as far as what the connected organization can be, again, it could be a C6, it could be a C4, it could be a regular for-profit corporation, in which case, if it's organized as a corporation, the corporation can pay for the administrative costs. However, if you're talking about for an LLC or an LLP that's not taxed as a corporation, those types of organizations will be organized a little bit different with their PAC because they're not corporate in nature, and it would be considered technically a non-connected PAC. So you'll see a lot of law firms that have PACs, in DC and throughout the country, or other organizations that are not corporate taxed as corporations. They'll have PACs and they'll be considered whatever firm PAC, but it will not be necessarily the same rules because it could be considered a non-connected PAC in those instances.
Yeah, and just to add to that, if you are making an SSF, a connected PAC within your existing C4 or C6, you don't necessarily have to separately incorporate that. So as Jim mentioned before, it's organized under 527 of the Internal Revenue Code, but it's really just a separate bank account. If you're making a non-connected PAC or a super PAC or something like that, and you want to incorporate, then you would incorporate a 527.
We also have another question that we can touch on just briefly, which is sort of just the difference between a super PAC on the one hand and a PAC or a separate segregated fund on the other hand. So if one of you guys wanted to maybe touch on that for just a quick second.
Sure. So I'll start with a PAC. A traditional PAC, and PACs don't need to be considered connected to a corporation to qualify as a kind of a traditional PAC. PACs are created all the time by the general public. Candidates, they'll create leadership PACs. these are entities to raise money, traditional PACs, entities to raise money within the limits, to pool money together, and they're typically to make contributions to candidates. That's what kind of a traditional PAC does. Now, that doesn't mean traditional PACs can certainly do independent expenditures, but the super PACs are better for independent expenditures as far as that goes, because they're able to take unlimited amount of funds in order to do so. So after Citizens United, there was a number of court cases. There's the Speech Now case, and then the FEC came to the determination that corporations can give or make make expenditures in unlimited amounts. So can individuals pooling their money together with corporations and other organizations to create PACs that are independent and able to make independent expenditures in unlimited amounts. And so that's kind of really the main difference with regard to PACs, traditional PACs and super PACs. Super PACs, going back to the coordination piece we discussed earlier, that's something that needs to be a prime concern when dealing with the super PAC, to not trigger any of the the conduct prongs or the content prongs, such that any kind of communications could be deemed coordinated and therefore impermissible. So I guess we were on FEC reports. FEC reports are, going back to kind of the periodic reporting that we discussed earlier. These are just reports that need to be accurate. They need to be, within the 48-hour period or the 24-hour period. But contributors need to be listed as well. So for super PACs, contributors, any contributors over $200 need to be disclosed. As well, that goes the same for separate segregated funds, where essentially an FEC report that is from a separate segregated fund will basically just list employees, or members of the restricted class that gave to the PAC. And again, the reporting schedule, which we touched on earlier, election year, quarterly reporting, plus those 24-hour, 48-hour reports as necessary. In off years, for super PACs, it is semi-annual sort of thing, but in off years, you can either do monthly reporting or quarterly reporting. And then, of course, any kind of PAC operation needs to have compliance procedures in place that will make sure that all records are being retained for 3 years, which would include, a record of all receipts, disbursements. In a trade association context, any kind of signed prior approvals, signed payroll deductions, which is oftentimes how separate segregated funds raise money, is their payroll deduction. And then there's obviously donor forms, and then bank statements. These are all things that an organization will want to have if there is ever any kind of FEC audit or FEC complaint. These are the documents that they'll want to have in place. And we touched on contribution limits earlier, but new PACs actually have a little bit of a different limit than established PACs, separate segregated funds. A new PAC, so say a corporation creates a new separate segregated fund, that PAC is limited to $2,900 per election to a candidate. Whereas as a PAC gets a little bit more established, they get deemed a multi-candidate PAC, and they have a higher limit to give to candidates. And becoming a multi-candidate PAC simply involves in existence for 6 months, and make contributions to at least 5 candidates, and received contributions from 50 different contributors. That could be in any amount too. So 50 contributors making $10 contributions each, that will qualify a new PAC to be a multi-candidate PAC and avail themselves of the additional limit. And then as far as PAC events for candidates go, if your separate segregated fund is going to have an event for a candidate, the PAC would pay for the food and the beverage, any kind of room rental. If you have it at the office, then you just need to determine a fair market value for the usage of that office for the specified period of time during the event. The PAC would invite the attendees, and it would include the restricted class or others not with the company. And the PAC pays for the corporate staff time. So if you have assistants or paralegals or any kind of other support staff that helps out, their fair market value would need to be determined. And really all of that is treated as an in-kind contribution to the candidate, subject to the 5,000 limit per election. So that needs to be taken into account. Does the fair market value of all these things that the PAC is providing for this event for the candidate exceed $5,000 per election? And if so, perhaps there needs to be a reimbursement from the actual candidate committee. And restricted class events in general, really it's limited to a restricted class, which those employees outside the restricted class are, unless they're necessary for the event. It can involve special guests, speakers, and you can urge. These events involve speeches where maybe someone would be urging attendees to vote for a specific candidate. Contributions can be solicited for the candidate. You cannot, the PAC cannot collect contributions. It must be given directly to the candidate. And the PAC can provide food and beverage. There's no charge for the room, and it can limit to one candidate and not include opponent. So.
Great. Well, thank you all for attending today. Jim and Lindsay, thank you very much. Those fantastic presentations. We will, the materials, a recording of the presentation along with the PowerPoint slides will be available on our website in just a few days. We will email out the CLE code to everyone as well. If anyone has any other questions in the next minute or two, feel free to send them into the Q&A chat there. We've got a minute or two before we hit 1:30, and we're happy to answer any questions you may have. Again, thank you for your time this afternoon, and I hope you and your nonprofit organizations all have very successful election years in 2022 this year. So thank you.